The implications of this judgment are simply that it shows that the right to impart and to receive information, and also the media rights in terms of Section 61 of the Constitution are being trampled upon in a way, because this is a case of intense public interest, where we would have expected, because we are talking about 12, 15 or so candidates running for the National Assembly who stand to be dismissed right across the seat. And the court has not denied that it's a case of intense public interest. That is why it allowed a limited streaming of the judgment, of the rulings. But however, as you will note, that the rulings are normally just one-liners. And the ruling is made against a background where people do not know what was being debated. And as it is, judgment has been reserved, meaning that the ruling is going to be made on some other day. And it is quite possible that it might be also a one-liner where the operative paragraph is read. And to that extent, the public have been starved of essential information to know what goes down or what goes on in the hallowed halls of the law. Why should we have courts where the public do not access, when the idea of the courts is that it is a system of open justice? And we would implore the court or call upon the courts in future to allow streaming and to put in place rules. In South Africa, they have rules of how people like you as journalists can approach the court to apply to participate in streaming, and they have guidelines. And our constitution allows for that. Our statutes are actually open to that. What we need are guidelines. In New Zealand, they have guidelines. And we would implore the courts to put in place those guidelines, to make this easy for you, and to make cases such as this opened, so that the public do not accuse the establishment of hearing these cases under closed doors. In fact, funny enough, this was one of the issues in this case, whether a nomination court can be done behind closed doors or it should be in open court. So we as legal, as representing our client, Kula Sizwe, they are extremely disappointed. Critical fact is that none of the parties objected to the live streaming. I think it is just a fear of new technology, fear of the unknown, and eventually we will grow out of it. And the courts will put in place guidelines to allow you to be able to stream to our benefit as members of the public, so that we can all know what is happening in the courts, especially when the result is so monumental, is potentially monumental, and the public should be able to understand what happened.